the Krishna Janmabhoomi dispute, the Mathura Court has said that there should be a Gyan-Vapi-like survey. A date has been fixed, 20th of January is when the survey report has to be tabled. But the likes of Owaisi have called this Sanghi agenda. Before I bring in two legal experts who will take on each other, here is what Asaduddin Owaisi said.
I am saying that the lower court order of asking for a survey is a wrong order. Why? Because number one, it violates the 1991 Places of Religious Worship Act. वो already proven है कि यहाँ पर ईदगाह है, वहाँ पर मंदिर है. 19 Places of Worship Act अभी भी है, पार्लियामेंट का कानून है, लॉ है 1991 का, जो ये कह दिया कि 15 अगस्त 1947 को बाबरी मस्जिद को छोड़कर जितने भी प्लेसेस ऑफ वर्शिप हैं, चाहे वो मुसलमान के हो, हिंदुओं के हो, ईसाइयों के हो, सिख के, उसको डिस्टर्ब नहीं करेंगे.
Viewers, the Mathura Court has ordered a Gyan-Vapi-like survey in the Krishna Janmabhoomi case. Joining us are two individuals with two distinct point of views. Waris Pathan is with us, leader of the AIMIM. Vishnu Jain, advocate on record of the Supreme Court, but more importantly, someone who wants the restoration of Kashi and Mathura. Waris bhai, I want to begin by asking you, when the court order came about conducting a survey in Mathura, the Krishna Janmabhoomi case, Mr. Owaisi came out and said that, look, this is Sanghi agenda.
First, let me tell you, in my opinion, the order per se is bad in law. It's without application of mind. It's a violation of the Places of Worship Act 1991, which says that prior to 15 August 1947, all the religious places which are there, whether it belongs to Muslims, Hindus, Christians or any, you cannot change the nature and character of the place. And passing such kind of order is total violation of the Places of Worship Act, which is still into consideration. And I am hopeful and sure that the Idgah Committee will definitely move the higher court against the order, and the higher court will take into consideration that it cannot survive and the order will be thrashed. Now kindly try to understand, on 12th October 1968, an agreement was entered between the Idgah Trust and the Krishna Janmabhoomi with the express approval of the Sunni Waqf Board from UP. So this is our Idgah, that is your Janmabhoomi. No ambiguity among them. So why all of a sudden the BJP, the Vishwa Hindu Parishad and the RSS wants to create the atmosphere of hatred?
Where's the BJP and the Vishwa Hindu Parishad in this? Because, Mr. Pathan, in all fairness, this is an order by the court. And let me remind you, you were talking about the Places of Worship Act. This is what Justice Chandrachud said in his oral observation on May 20th, 2022. And I'm quoting now. We are also concerned about these issues, but the ascertainment of the religious character of a place as a procedural instrument may not necessarily fall foul of the provisions of the section 3 and 4 of the Act of the 1991. So, ये तो वही procedural बात है, sir.
Well, the survey order which is passed by the civil court was passed without application of mind. Survey should be the last resort. I am a legal person, I am a lawyer, I know, and my learned colleague Vishnu Sahib is also there on the debate. Ask him, first you have to ascertain whether a place belongs to the trust. No, then how can you go for survey directly? How can you pass the order for survey? And why say BJP, the Vishwa Hindu Parishad? They were not even party during the Babri Masjid issue. But what happened, we all saw, all of a sudden they came up saying that the Murti Prakat ho gayi raat ke andhare mein, they locked the Babri Masjid. And on 6th of December 1992, what we all saw, the killing of the democracy was killed in the country and our Babri Masjid was shaheed.
Okay, so
it was martyred.
And
what happened after that, you all know in the country. And that is why we say
we are not attracted in this matter at all. And against that order, the Idgah Committee is in appeal before the Allahabad High Court. That is point number one. Point number two is that the Places of Worship Act does not bar the ascertainment of religious character. Point number 3 is that in this particular given facts of the case, the Places of Worship Act is not attracted because we have challenged the compromise which was entered into illegally by Krishna Janmabhoomi Sangh on 12th of October 1968. So places of worship, we are arguing within the scope of Places of Worship Act, that on 15th August 1947, whatever is the religious character of that premise in question, let there be the same religious character, and please allow us to give evidence that religious character on 15th August 1947 of that very place of 13.37 acres of land of Sri Krishna Virajman belongs to the deity. So at least in this legal setup, I have a right to at least adduce evidence so far as this aspect is concerned. And my last point is that Waris Bhai said that the order of appointment of commission is erroneous. Let me tell you that under Order 26 Rule 9, read with Section 75 of the CPC, the court has discretionary power to appoint commission, and there is no provision in the CPC to give prior notice to any party. And Waris Bhai can correct me if I am wrong. There is no provision in the CPC whereby the court has to give a prior notice to the other side to see whether commission should be appointed or not. This is the discretionary power of the court. Point number 1. Point number 2 is in this matter I want to say that when the commission is appointed, then the defendants will participate in the commission, and please don't compare this commission with the commission which happened in Gyanvapi, because this is just a commission of a very initial stage. This commission will only ascertain demarcate the boundaries. It's an AIMIM commission, which is a court staff which will go to the premises in question and ascertain that how much boundary is in whose possession. This is not
have been the last resort is what Mr. Pathan is saying, but your counter, and I'm sure Mr. Pathan would come in on this, you're saying that this is all within the ambit of the Places of Worship Act. Mr. Pathan, a quick response, then I have a question for you.
Yes.
Well, let me remind my friend Mr. Vishnu Jain that the Places of Worship Act 1991 is still into existence. And what was the intent of the Places of Worship Act was to see and to ensure that after the Babri Masjid, no such kind of incident takes place in our country. No such kind of places of worship, structures, anything, the nature or character can be changed. Because we all saw what happened in 1991, 1992, that era. The intention was there, but here with the malified intention, the Vishwa Hindu Parishad, the RSS,
malified
the BJP have
intention
come
of the
before the
court.
court.
Whose
And
malified
they just want to do
intention?
a survey. Now Vishnu Jain judge have said.
No, but whose malified intention, Mr. Pathan?
Of the RSS and the BJP, I am telling you.
But what has that got to do? The court is saying that do a survey.
Malified intentions of the BJP, the RSS and the Vishwa Hindu Parishad. They have moved. Why should they go before the court and ask for a
now
survey?
You tell me, sir, if you have a problem in this country, where should you go? Do you back Sadak pe Faisla?
They want to demark the place.
No, but if people have a problem, Mr. Pathan, if the appeal has been made to the courts to resolve the matter, you tell me, but what is the other option? Where do you go? If you have a problem, if you want to settle a dispute, where do you go?
What is the problem? No. What is the problem? The BJP, RSS, they just want to create an atmosphere of hatred. They want all of us to go into the era of the 80s and 90s, and what we saw was bloodbath, demolition of our Babri Masjid.
Mr. Vishnu Jain, what is the problem?
Babri Masjid ko. They want to take
Why
us
are
into
you
that
pursuing
era.
this Sanghi agenda? What is the problem?
Why was the Places of Worship?
No, Mr. Vishnu Jain will tell you what the problem
there is. Nothing.
I'm asking a simple question. The intention
He'll answer
of
that question.
to be taken into consideration.
See, the cause which I am advocating and the cause which I am representing for my clients is not a Sanghi agenda. It's an agenda which has deep research and has a deep rooted thinking. And the thinking is this, and the fact of the matter is, let me place certain facts on record, that in 1815 Raja Patnimal has purchased this property from the British government in auction. So point number 1 is that 13.37 acres of land, the ownership of that land is ours. We have papers for that. So Mr. Waris Pathan, you can ask him that is there any paper of ownership of the mosque committee? I think there is none to my knowledge. So 13.37 acres of land on papers is owned by us. No, 1968 agreement, that's, I'm coming to that. After 1815, the property was given to Pandit Madan Mohan Malviya in 1944, and in turn Pandit Madan Mohan Malviya created a trust which is known as Shri Krishna Janmabhoomi Trust. The original owner of this property as of now is Shri Krishna Janmabhoomi Trust, who is a Shibayat who is holding the property for the purpose of the deity. Now a fake sanstha has been made in the era of 1960, and the name of the sanstha was very similar to Shri Krishna Janmabhoomi Trust, and the name of the sanstha was Shri Krishna Janmabhoomi Seva Sangh. And Shri Krishna Janmabhoomi Seva Sangh files a case, enters into a compromise with the Idgah Committee, and now Mr. Waris Pathan is saying that that compromise has been entered. But the fact of the matter is, Pranesh, that that compromise was not entered into by the lawful owner. How can a person enter into a compromise who is not even the owner of the property? And if I am challenging this before the court of law on the very basic principle that fraud unravels everything, where does the attraction of places of worship at comes? I am saying this, Waris Bhai, on the basis of the documents which we have filed in the court, and this will be adduced in evidence. This will be further led and tried by the civil court. But you are trying to make a point that no, Mr. Vishnu Shankar Jain, you don't have enough a right to argue these things.
No. Okay, this is a case of impersonation. So you are saying that compromise. No, you are saying that compromise of 1968 was essentially a fraud on the Hindus, Mr. Pathan.
A fraud.
Yes. Now, allow me to make my point now. Let me make a simple point. October 12, 1968, an agreement came to be entered between the Idgah Trust and the Krishna Janmabhoomi. Now, as Mr. Vishnu, the deep-rooted agenda. Now, let the nation know what is the agenda.
What is your agenda, Mr. Vishnu Jain?
Plain, sir, you want to create an atmosphere.
You must come clean on the agenda. Vishnu Jain, Waris Pathan is today daring you to come clean on the agenda.
And this is, have they filed any case? There are documents.
Yes.
Documents speak for itself, sir. There are documents of 1968.
Why the delay in filing a case that this is an afterthought? And what is your agenda? Mr. Pathan wants to know what is your deep-rooted agenda. His words, not mine.
Point number. Yes. See, point number 1 is that the Supreme Court in Ram Mandir's case, in para 428 onwards, has categorically held that when the Shibayat is negligent, a devotee has a right to file a case on behalf of the deity. If Shibayat is negligent and that property of the deity is transferred and there is negligence on part of the Shibayat, a devotee or a worshipper can come at any point of time and law of limitation will not be attracted in those facts of the case. So that's the answer so far as delay is concerned. And the second fact is that in 1997 a case was filed before the Allahabad High Court, and Allahabad High Court said the same thing which I am today quoting on your channel, that Seva Sangh and trust are two different bodies. If compromise has happened through fraud, then someone can challenge it in the civil court. So therefore the law of limitation is not attracted in this case, and law of limitation is a mixed question of law and fact which the courts will look into. We are at a very preliminary stage of this trial where you are not allowing the trial to go on the point of... See, the worshippers didn't know. Mr. Pathan, the fact of the matter is worshippers didn't know. And when the moment worshippers came to know, and when the moment
Mr. Pathan, but sir, in all fairness, Mr. Pathan, the Hindu faith, 1 minute, Mr. Pathan, in all fairness, I am sure you will agree that the Hindu faith, let's address the larger question, Mr. Pathan. I am sure you will agree, you are a reasonable man. The Hindu faith has been under assault for a long time. There are many, multiple frauds like these on multiple cases in not just Uttar Pradesh but across the country. Now, tomorrow, when I am coming to you, make Mr. Pathan answer.
Now, what about my faith? Now, will the country? What about my faith, sir? Will the country run on faith or the country run on constitution?
Who's saying the country will run on faith? Nobody is saying that.
Follow the rule of law.
Which is why I said when you said in the beginning, why have these people got to court?
You said about the faith of our Hindu brothers where...
No, Mr. Pathan, you said why have the people gone to court? If you have a problem,
already we have all burned our hands, sir. Already, why should have the Places of Worship Act into existence? There is a Places of Worship Act 1991 which is still into existence, and as per that act and as per the law which is formed by the parliament, any structure or any place of worship prior to 15
But I just read out what Justice Chandrachud said in his oral observation.
Place. As simple as that.
Is this not under the ambit of the Places of Worship Act?
Let the matter
But
be
even
decided.
if it is not, you should go to a higher court.
This
challenge
does not
it.
come under
Why should you demean the
survey
court
is the
and
last
say this is a
resort.
Sanghi agenda?
Survey should be a last. First, let them let them challenge. First, that the agreement entered into in the 1968 between the Idgah Trust and the Krishna Janmaboomi was illegal by fraud. That was obtained by a fraud. The agreement signed was a fraud committed. First, get an order on that.
Okay.
Then you can go for survey.
Last
Survey
word,
should
Mr.
be
Vishnu
the
Jain. Then we are
last
wrapping this
resort
up.
in such kind of things, sir. You cannot surpass this.
See, we have challenged, let me tell you, we have challenged the compromise of 12th of October 1968. And Mr. Waris Pathan, let me tell you that the deep-rooted agenda is to get our glorious history back. The deep-rooted agenda is that wherever the property of deity has been acquired through the might of the sword, that property of the deity we want to restore and recover through the power of pen, and give a message that pen is mightier than the sword. Whatever has happened in the slave era, that slave era will not continue after Article 13, Subclause 1 has been enacted, and all those laws and all those orders which were passed in slave era are erroneous and are in contravention to the Constitution, Article 25, and therefore we have a right to approach the courts of law, and the courts of law are exercising sovereign power.
Okay, gentlemen, we've run out of time. I thank both of you for joining us. Let's see the blame game continues. The bitter war of words rage. Let's see how this case unfolds in the court of law. That's where we must focus, not on any other place. Mr. Waris Pathan, Vishnu Jain, thank you for joining us on India Upfront.